Hello and welcome. We are Team Denehy. If you're listening, you are likely navigating one of the most difficult seasons a family can face. Alongside the profound grief of losing a loved one, you have suddenly been handed the complex, demanding job of an asset manager. There is a heavy friction in this process. A grieving family naturally seeks swift emotional closure. You want to sort the belongings, sell the house, and move forward. But the legal system operates on a strict requirement for due process, which demands time, patience, and absolute precision. This flowchart illustrates the gap between family assumptions and legal reality. The expectation on the left, inherit, sell, and distribute, is crossed out. A will is merely a set of instructions, not immediate authorization to liquidate. The reality on the right shows the required court path. Inheriting a property is rarely a sudden financial windfall. It is the immediate assumption of a highly regulated, risk-bearing asset management project. The biggest misconception is the belief that being named in a will gives you the right to sign a real estate listing agreement. It does not. To gain that authority, you need a specific legal mechanism. Depending on whether there was a will or not, these documents are known as letters testamentary or letters of administration. The local probate court must officially review the estate and grant these documents. Only then is the executor legally empowered to sign a deed. In Tennessee, state law dictates that property vests in the heirs immediately upon death. However, vesting simply means you have an underlying interest in the property. It doesn't mean you possess the clean title a buyer's bank will require before they fund a mortgage. Without securing those letters testamentary and verifying a clear title first, any attempt to sell the property will inevitably collapse at the closing table. Worse, attempting to bypass the court exposes the executor to immense legal and personal financial liability. Once the probate process begins, executors hit a specific, unavoidable roadblock dictated by state law, the Tennessee 4-month creditor period. This mandatory waiting window exists to protect anyone the deceased may have owed money to. This 4-month timeline is strictly designed to flush out outstanding debts, unpaid medical bills, and hidden taxes. The real estate asset is completely frozen until this countdown expires. Ignoring this makes it absolutely impossible to guarantee a clean, insurable title. Executors who try to distribute funds to heirs before clearing all creditors assume strict personal fiduciary liability. If a valid medical bill surfaces in month 3 and estate cash is gone, the executor pays that debt out of pocket. The probate timeline is non-negotiable. For at least a third of a year, your immediate job title shifts permanently from property seller to property protector. While the legal timelines tick away in court, you must manage the physical asset. An unoccupied property carries immediate vulnerabilities. Families naturally prefer leaving the house vacant. It provides easy, private access for sorting through decades of personal belongings, and it avoids the immense complication of evicting a tenant down the road. But an empty house introduces hidden liability. Standard homeowners insurance policies often invalidate coverage if a house is left empty for 30 to 60 days. You must proactively upgrade to a specialized vacant home policy to remain protected. Then there are the physical risks. It feels counterintuitive, but you must continue paying to keep the utilities running, especially during the winter months. Disconnecting the heating to save a few dollars on the gas bill can lead to frozen and burst pipes. The resulting water damage will cause a catastrophic loss of estate equity before you even have a chance to list the home. You also have an ongoing requirement to fund external maintenance. Routine lawn care prevents municipal city fines from stacking up and wards off potential trespassers who target visibly abandoned homes. Surviving the mandatory legal holding period requires proactive, out-of-pocket asset protection. You must spend money to prevent the property from draining the estate's cash reserves. Eventually, the 4-month wait ends, the title is cleared, and you can finally transition to your ultimate objective, finalizing a sales strategy. This comparison matrix maps out the core strategic trade-off executors must weigh. You are balancing holding risk and upfront capital on the vertical axis against the estimated net payout on the horizontal axis. You must prioritize either speed and simplicity or maximum estate value. The first option sits low on the risk and capital scale, an as-is sale directly to an investor. This provides a rapid, hassle-free liquidation. You skip all repairs, cleanouts, and showings, but you purchase that convenience by sacrificing top-of-market equity. The second option moves up the matrix, light renovations for the retail market. This route mathematically maximizes the final inheritance payout for all the heirs. However, it requires significant upfront capital to fund repairs and demands active, daily project management. There is no universal rule here. The correct sales strategy is an objective calculation based entirely on the estate's available cash and tolerance for risk. There is one final, often volatile variable in the executor's equation: sibling consensus. Competing family dynamics and differing opinions over the sale price can stall a probate sale for months. This decision tree helps remove emotion from the equation, matching your family's specific scenario to the correct sale path. It starts by asking if the siblings are aligned on their goals. If your family is geographically dispersed, time-poor, or prone to disagreement over repair budgets, the best choice is usually the as-is investor route. It limits conflict and preserves family harmony. Conversely, if the estate is cash-rich and there is unanimous agreement on maximizing the return on investment, the family can confidently absorb the holding costs to perform strategic, light renovations. Regardless of the path you choose, managing complex sibling dynamics alongside strict legal timelines demands extreme transparency and professional third-party mediation. Do not attempt to be both the grieving family member and the unbiased project manager simultaneously. The burden is simply too heavy. For a step-by-step guide or a confidential evaluation of an estate property, call Team Denehy with Mitchell Real Estate at 702-569-9557.